Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is Jaclyn Phillips. Hello, Jaclyn.
Hey, Matthew.
Today's episode is All Change or More of the Same? UK Merger Control Developments. We'll be discussing a package of changes that will affect UK merger control procedure and practice.
Our guest today is John Schmidt. John is a solicitor at the law firm Arnold Porter, where he heads its London competition team, advising on both UK and EU competition matters. The London practice covers merger control, investigations, behavioral counseling, and competition litigation. Hello, John, and welcome to the show.
Hi, Jaclyn. Hi, Matthew. Thank you very much for the introduction and welcome.
Well, thank you for coming on, John. By way of introduction, I'm going to remind listeners that the UK Competition and Merger Control Regulator, the Competition and Markets Authority, or CMA, became a fully standalone regulator at the beginning of 2021. That was when the transition period following the UK's exit from the EU ended. From that point, under the previous Conservative governments, it developed a reputation as one of the toughest merger control regulators in the world. That led to criticism and concern in the business community, not least as a result of the CMA's review of Microsoft's acquisition of Activision Blizzard that we covered in our Curious Amalgam number 239 from September 2023. The Labour government elected in the UK in July 2024 has, or had, what it called a growth agenda, and one of its points of focus has been the performance of regulators such as the CMA. So, John, with that as background, could you please give us a bit of detail on how the UK merger regime is structured so we set the scene some more?
Yes, I mean, the UK merger control regime is quite a regime. It existed before the CMA came. It's a little bit quirky and or different run to some of the regime of Europe or indeed in the UK. Yes, generally a voluntary regime, so that means there is no general notification obligation and there's no suspension obligation. Those are the two biggest differences to other merger control regimes. But there's also other differences. The jurisdictional tests are slightly differently structured. Jurisdiction is triggered either by the target's revenue alone, target revenue, or by a share of supply test, where the target and the acquirer overlap and they reach certain share of supply levels. Where there's an increment involved, you need to have, and that triggers a potential review by the CMA. There's now also a new hybrid. It tries to capture things such as killer acquisition way to the rest of Europe. That works slightly it hangs off a revenue threshold and a share of threshold. And as you said, since Brexit, the UK merger control regime sits alongside the EU and now you have therefore jurisdiction in the same case essentially as the European Commission, which then leads to parallel review, where previously Europe was looking at it, also including the fact that it's a voluntary regime and doesn't have a suspension obligation also means that the CMA has a special unit, monitors mergers that potentially haven't been notified that it may be interested in, and it regularly requires information in respect of non-notified mergers. The powers it has to review are broadly the same as notified mergers and broadly the same as that other regulators or others have to pre-notice in their jurisdiction.
John, before you go on, I just had a quick question. So when we're looking at the reform package and sort of what's going on, Is there kind of anything more we need to know to set the stage about what happened here?
Yes. I mean, the drive for the reform package, I said, came from the new Labour government, the government that was brought into power in 2024. There is a focus on growth for the UK economy. The government looked at different regulators, the whole regulatory landscape. That is, and the way the CMA has been operating, and there's been an increased political pressure on the CMA to contribute to that growth. Early in the year, that led to the replacement of the CMA by a new chair, and in parallel, the CMA has then brought out its agenda for reform and started different strands of reviewing how it's looking at the process, how it's looking at cases, and how it could become more efficient, more effective, and how it could contribute to that growth agenda.
Thank you. That's helpful context for this discussion. And you had started to talk about where jurisdiction lies, and I think that's a good place to begin this conversation. So, from your standpoint, do you think there will be more or less CMA reviews given the changes that we've seen?
Let me just very briefly say what these changes are. I think there's three strands. There's three broad buckets of change around the jurisdictional and procedural guidance that the CMA has given. That's a final draft, that's adopted, and that's the first bucket. The second one is around merger remedies, which is still under consultation, or where the consultation is closed, but is. And the third one is around institutional changes, which is not proposed by the CMA, but proposed by the government. That's still under consideration, but those are the three areas that the overall reform package. In short, I think we'll probably have less reviews, but more streamlined reviews. If all those changes we'll have less detailed reviews. We'll continue a trend that started some time ago, even before were adopted, around sifting out the non-problematic cases at a very and for that the UK has a different procedure. A couple of years ago, a bit longer. Between a formal notification and not liaising with the CMA at all, you can have an informal dialogue based on a very short pre-notification, a 5-page memo going into the and it operates as a triage system where uncomplicated cases get essentially an early termination, a de facto early termination confirmation. We will continue to see that. I think the reform package formalizes that process and formalizes the CMA's view that this is a beneficial process. So we'll see less of unproblematic cases full through, and those that do, certainly the less complex ones, see a more streamlined view in phase one, and therefore a shorter review.
John, as you say, the informal briefing memorandum route has become increasingly important. I'm interested in your thoughts on the proposals in the jurisdictional guidance or the comments about the material influence concept and the share of supply test. These are both being looked at. So could you just set out what those are in more detail and what the comments are about those?
Yes, I mean the driver for them are the CMAs. I think the two CMA buzzwords I would say are pace and predictability. They've got a 4P buzzword sentence that they try to live by. On jurisdiction, we've seen in the past cases is certainly a perceived, possibly an actual expansion of jurisdiction into different ways, the way that the CMA has applied the share of supply test, the way the CMA has looked at the UK as a jurisdiction in the UK. And one of over the years has gradually also seen a wider application is the material influence concept, which essentially defines as a transaction, as a reviewable merger, not only acquisitions of joint or sole control, but also acquisitions of significant stakes below control level, at an influence level. Historically, the community starting position was around 25%, and that has been eroded over the years to anything over 10, 12% have been found in relatively exceptional cases, but in a string of cases, as conferring potentially material influence and therefore being a merger situation that the CMA can review. And in the latest guidance, the CMA is essentially reverting back to the old position that a 25% shareholding is usually your starting point for it to be a merger situation. There can be exceptional circumstances below the shareholding level, but broadly speaking, they need to be very exceptional. And essentially, we're seeing the tide turn back to the 25% as your starting point for it.
It's just useful to note that it's not a safe harbor. The CMA does leave itself scope to review less than 25%.
That's correct. And how that will be implemented, I mean, the proof of the pudding, as always, is in the eating. If the exceptions start again, then that could undermine the guidance. The mood music clearly is that the CMA wants to go back again, but it has a lot of flexibility on that.
And then you were going to comment on the share of supply test. So this is how the market share or equivalent market share thresholds are calculated. What factors can be looked at to determine whether the relevant threshold is reached? That's
correct. And the CMA is very proud of the share of supply test and the fact that it's called a share of supply test and not a market share test. That has in itself led again to perceived widening of the juris scope. The reason why it is called a share of supply test is that the CMA has a large degree of discretion on how it applies it. There have been some cases in the past, especially post-Brexit, where that has been used in a very flexible way. It's been perceived as too wide. And the CMA, again, is rolling that back to the metrics that are originally mentioned in the legislation, that they will look at shares by volume, shares by value, cost, capacity, number of employees to establish that share of supply. Again, it's a trajectory, it's guidance. The CMA retains its flexibility in hard cases, but we're seeing them signaling that they are likely to be less creative around how you establish jurisdiction beyond the metrics that are given in the legislation.
It's still interesting to note, I think, that even the metrics in the legislation are pretty wide, as you say: volume, value, cost, capacity, number of employees. So there's quite a scope there anyway remaining. You mentioned as the second bucket the remedies reform. This seems to me potentially to be even more significant than the jurisdictional questions we were just discussing. So what are the main themes in this area of the potential changes, John?
I think the biggest thing to kick off with is, and I should say these are draft remedies, they're still not finalized yet. The CMA has committed to finalizing them by the end of the year, so we need to see whether they stick to their KPI or whether there will be some delay on that. The key message is that behavioral remedies are becoming more viable, and that is particularly the case in phase one, where in the past with behavioral remedies, firstly, they were very difficult to get past the CMA, and secondly, practically not in phase one. For them to be viable, the CMA would have needed to look at the case in a detailed phase two, and then you can have your discussion around behaviorals. They have started accepting some behaviorals or some hybrid already in phase one. So in a way, it's the guidance catching up with the trialed cases. But that's a significant change in that they're now showing a willingness to accept behaviorals in phase one already, and that behaviorals are sometimes also more appropriate and more proportionate, whether that's phase one or phase two. Does that open the floodgates to behaviorals in merger cases? Probably not, but it certainly moves that debate somewhere, somewhat in particularly in phase one cases. That doesn't change the fact that the CMA will prefer structural over behavioral remedies. It will not change the fact that behaviorals need to be very clear cut to become viable and to become acceptable, that the onus is on the parties to present robust, justifiable evidence of how they would work well, and how the complexity that it invariably is introduced with behaviorals is manageable. So the onus is on the parties to demonstrate that. In a context of phase one, the timing is very short to demonstrate that. But the big point is they are becoming more viable now. There's a willingness to accept them in phase one in the right cases. And we've had one case already that had these kind of remedies adopted in a very UK-centric case involving house builders in the past.
As you say, some flexibility, but I think it's important to note that the CMA in this proposal does emphasize, as you mentioned, that if you like, traditional requirements will still be there. So they will focus on effectiveness first. Will it be effective? Followed by proportionality in a particular circumstance. Relevant to this, I think, also is the question of how they look at carve-outs. Is there any comment or you can make on how these will be looked at by the CMA?
Yes, I mean, carve-outs can work. There is a willingness to look at it. But carve-outs can also present an additional set of complexity, and that needs to be addressed. That needs to be worked through. That needs to be presented to the CMA.
Finally, on this remedies issue, John, as listeners know, there's a lot of discussion in the EU and elsewhere about the relevance of efficiencies, whether merger-specific efficiencies, and also the UK uses this specific term, relevant customer benefits. So being interesting to hear your thoughts on how these issues will be worked in, whether they're considered in the reform document, and to what extent these are going to become increasingly relevant for UK cases.
The short answer is yes, they are considered in the document at a brief level. I think the big point there is that the CMA, again, it gets you back to your evidence that you need to present, how robust that evidence is on relevant consumer benefits. And they have flagged that there will be a lot more on relevant consumer benefits in the next wave when they look at the substantive assessment of efficiencies, and they're likely to expand on that then. I think the other point I just briefly want to mention in that whole remedies debate, particularly in phase one, the CMA is also very keen to introduce a much earlier discussion around remedies. And that's important because in the past that has been a significant hurdle. The CMA, and it's been a hurdle on both sides. The CMA often felt it wasn't in a position to have a discussion around remedies until it's concluded, the hierarchy has concluded its views on the theories until relatively late in the process. The CMA is now offering a willingness to engage earlier and to engage earlier on a without prejudice basis. Sometimes the parties have tried to push that discussion, and they were rejected by the CMA, who wasn't in a position to discuss it. Sometimes the parties have been reluctant to have a debate on remedies without the theory of harm being sufficiently articulated that they could address it, and putting hypothetical remedies on a table or flagging that potential hypothetical remedies could be available is quite difficult when parties then may perceive that the CMA would just take whatever remedy is on the table and work its harm around that. I think the experience that we've seen with other regulators, particularly in Brussels, that system can work very well, where you have a hypothetical discussion, you put draft remedies on the table that, if the theory of harm substantiates it, can become available, and they can be handed back if it doesn't. The effectiveness of that very much depends on, I think, both sides coming to the table early and having those hypothetical discussions. In Brussels, it's worked well in some cases, and we can see that would work well in the UK if it's appropriately adopted on both sides of the table.
As you say, always an interesting question, and the clients are often unwilling to propose remedies even without prejudice for obvious reasons.
Yeah, and just turning the discussion a little bit to phase two reviews, you flagged that there may be some institutional changes for phase two. Can you tell us more about the landscape there?
Yes, this is a proposal that doesn't come from the CMA. That's a proposal that was that came from government. It's still in the early stages. Government has flagged that is something they're thinking about. And the core of that is that it removes one of the last relics from the quirky pre-CMA regime. As Matthew has flagged, the CMA was created out of two authorities, previous authorities, the old Office of Fair Trading, that was a phase one authority, only a phase one authority, and the Competition Commission, that was only a phase two authority. And if you had the OFT decide that a case merited a phase two review, it was then passed over to the Competition Commission. The idea for the reform was to create efficiencies by having a single tier authority. But one of the aspects that was retained was that the phase two decision is not taken by the same case handlers that took the phase one decision. Unlike other authorities where the final decision maker is the same throughout, that is not the case with the CMA. We have a panel system in the UK that is akin to the members of the Competition Commission, that drawn out of the wider competition ecosystem, including professional former economists, former competition lawyers, civil servants, business people. They're not employees of the CMA, but they sit kind of quasi-independently and then take the decision in phase two cases. The benefit is to protect against confirmation bias, institutional groupthink, and that was seen as worth preserving when a single tier CMA was brought in. The current proposal now is to remove that panel system altogether and to place the decision-making authority with the CMA's board. So it becomes an entirely internal CMA decision, but it will be at the very senior level of the CMA. And the aim, the government's aim, articulated aim, is that this will lead to more effective and quicker decision-making. How that will unfold, we need to see. That not many details have been proposed, but that is the broad idea. So that can have a significant change in phase two cases, a change in dynamics.
I suspect, based on what you said on where they are with the proposal, that you don't have a sense of when you might see those institutional changes come about.
Not at the moment. Government can move very fast if it finds parliamentary time, and it can be slow if it gets dragged into a wider consultation. So we'll need to see.
So John, to the non-UK listener, this all sounds a bit kind of inside baseball and technical. I mean, how many times do you think the panel actually disagreed with a recommendation from the case team? So will this really make much, if any, difference in substantive terms? I guess it may potentially speed things up a bit, but in reality, what do you see as the actual change here?
I think if you articulate it as at what stage does the panel completely fundamentally disagree at the end of the process, I think it's hard to speculate on that from the outside. I think the benefit of the panel system was that you had interaction with the panel during the review. You had guidance from panel members. You had an overall feeling that our decisions will be looked at by somebody entirely different. So I think that does have an effect on the case team, but possibly not quite the same effect as having an entirely different authority then come to entirely different situations. And when the change was made originally, there was some cynicism around whether having a panel system really retains the benefits of having an entirely different set of eyes review that. I've seen it in different contexts where the panel actively contributed to a significantly better decision than without the panel, but that was in slightly different contexts. So I think the change is one more of not so much of a head-on argument and the panel then taking a decision. It's more the fact that it's there will make a difference in decision making. And then the question is, which system are we getting into now? The CMA board are significantly senior people that are also have a hallmark of independent decision making. So the point there is they're not immersed in the case team in the same way that the panel isn't immersed. One can take the view that a CMA board decision, also has that quasi-independence. The slight difference, and that may or may not be significant, is the fact that the CMA board is integral to the CMA, and it is ultimately the government that appoints the CMA's board. And we've seen at the beginning of the year that the government very publicly forced out the current CMA chair. So there is the potential for more political pressure put on the CMA board than there is on panel members that may or may not respond to government pressure.
Interesting point there. Maybe that's the rationale behind it all. So I think, John, for non-UK listeners, the most interesting thought finally here is how this will impact the way UK merger control fits into international deals. I think it's fair to say that the overall concept from the Labour government's so-called growth agenda is to make the CMA take a lighter touch on wider deals that are just, if you like, indirectly impacting the UK, or which can be dealt with without a big UK investigation. So how do you see this will impact that issue, where UK merger control fits into big international deals?
I mean, from my perspective, I think this change is more incremental. It's not a revolution in the way that the CMA will look at it. A lot of those changes in some way have already been implemented. I've seen that in case reviews over the past year, where certainly in my experience, there has been a very pragmatic way in which the CMA has looked at cases. Yes, there have been some controversial cases, but overall, I think a lot of the changes that are proposed formalize the approach that the CMA has taken in the past. We've seen the briefing memo route being an effective triage system, not just to filter out non-controversial cases, but also to identify those cases which, if the UK was the only country involved, the CMA may have more of a role to play. But if it's wider markets where other authorities are looking at the case that includes the UK, or where any remedies are proposed that may actually solve a UK issue, we've seen the CMA take more of a wait-and-see approach in a number of cases. And I think this guidance formalizes that. So I see that more as a continuation of the CMA's pragmatic approach and essentially formalizing that in more clear guidance.
Absolutely. And I think it's interesting also to note for our listeners that the CMA has other ways of dealing with cases. It has its de minimis exception, which it's making some use of for smaller or less impactful transactions. And it also has things like the counterfactual or failing firm, where you can implement the failing firm quotes defense, which has also recently been put into use. So, John, we like to finish, as you know, with some personal questions, just to make our listeners more aware of who you are. So firstly, please could you tell us something interesting or unusual about yourself, which we would not know if we only work with you?
I'm not quite sure whether it's interesting or unusual, but I started swimming again 2 years ago, and I enjoyed it very much. So I've started long distance swimming, and I swim about 4 kilometers as often as I can during a week, but I try to do it 2 or 3 times a week if working time permits. It's probably known about me. My family doesn't allow me to talk about it anymore because I enjoy it so much, and I've tried to spread the message to my colleagues as well. So it's not entirely unknown, but it's unknown by the wider community.
So is that open water, or is that in a pool? And how long would 4 kilometers take you?
No, it's in a pool. It's an outdoor pool, but it's a heated outdoor pool. So I'm not going to be not quite as hard. I'm not hardcore enough to do it in open water. And 4K is 160 laps in a 25-meter pool. So it's an hour and a half.
Oh, that's a very good effort.
Yeah, very impressive. I'm going to do our U.S. listeners a favor. That is about 2.5 miles, in case anybody was wondering.
Good translation. Thank you for that.
Imperial or U.S. miles?
And now we have our curious hat.
And now it's time for the Curious Hat.
All right, so one more surprise question for you, John. Hopefully this won't stump you. Are you reading any books right now? And if so, what are your thoughts?
Yes, well, I'm reading 2 books. I'll exclude the book that I'm reading to my 8-year-old son, which is Harry Potter, the Harry Potter series. I'm reading it for the 5th time, so that's nothing new. The other book, it's a kind of series of books that I'm reading on my travels, which is it's a series called Before the Coffee Gets Cold, by a Japanese author called Toshikatsu Kawaguchi, and it's a little collection of short stories that propose if you could go back in time, to have a conversation with somebody that you want to have a conversation with again in your personal life or something else, how would you do that? What would you talk about it? The key parameters are that you can only go back and have that conversation as long as for one coffee before it gets cold. You've got to go back to reality before the coffee gets cold. And as you get a bit older, more reflective, it's quite interesting that the questions it poses, and just to think about what you would do if you could go back for a coffee with somebody.
That sounds lovely. That sounds like a really great way to reflect. And I think I'm due for a Harry Potter reread with my 7-year-old. So I'm inspired by this conversation in multiple ways. So thank you so much, John, for all your insights into these changes. I think we've really covered a lot that'll be useful for our UK listeners, our international listeners, and really appreciate your time. And to our listeners, we'll see you soon on Our Curious Amalgam. Thank you.
Thank you very much for having me.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.